As I said, we've put this briefing session together today on what is a very extensive bill, and that wasn't an easy task due to the sheer breadth and depth of various different measures in the bill that have relevance to children and young people. We've got numerous concerns about the wide-reaching legislation and have been working really closely with our members and with various other coalitions that have got an interest in this area to examine the proposals in order that we can lobby for amendments on particular aspects. So as the name of the session suggests, the bill touches on everything from serious violence prevention to policing to courts and sentencing and through to criminal records. So it's a real breadth that it's covering, and we're going to try and do our best to kind of crystallise some of the main themes that have come out of that in relation to children and the youth justice system today. So unfortunately, despite how much the bill has in it, it misses a lot of opportunities to genuinely represent a smarter approach to sentencing and a smarter approach to how we deal with children. So there are opportunities to lay provisions in the bill around the age of criminal responsibility or ensuring that a child-centred and welfare-focused approach is taken forward. But as well as missing opportunities, some of the provisions are really dangerous and damaging for children and are being pushed through without any consultation meaningfully in order to give organisations like us and our partners across the sector an opportunity to input using all of that expertise. So there are some provisions that we do welcome and think that could be strengthened. And the session today will be highlighting some of those missed opportunities, as well as discussing the provisions that we think should be withdrawn or amended. So in order to try and make sense of what is a very wide-ranging topic area, as with our written contribution, we're going to break it down into three key areas for the purposes of the presentations today. So the first are the measures in the bill that fail to treat children as children. The second being those that fail to ensure that custody is a genuine last resort for children. And the third being the measures in the bill that really exacerbate existing racial disparities that are present and so acute already within the youth justice system. So the session today is going to focus on those three key areas. And the first of those areas that we're going to kick off with is inviting Jeremy Crook, who's the Vice Chair of Equal, to give a brief presentation about outlining his concerns and the concerns of across the sector around the particular concerns around the provisions that will exacerbate racial disparity. So if I could invite you, Jeremy, to kick off, please.
Thank you, Pippa. Yeah, pleasure to be here. As Pippa said, I'm Jeremy Crook, the Vice Chair of Equal, a national initiative that's trying to obviously improve outcomes for Black, Asian and minority ethnic individuals in the justice system. Many of the punitive proposals in the bill are set to disproportionately impact on Black, Asian and minority ethnic children. As we know, BAME people are over-policed, more likely to be stopped and searched and arrested, less likely to be diverted, and therefore disproportionately likely to end up in the criminal justice system. The Youth Justice Board research this year found for the same offences, BAME children are more likely to receive community and custodial sentences rather than out-of-court disposals, and are more likely to be remanded in custody. Measures in the bill will only exacerbate existing racial inequalities, and we are deeply concerned about that. And the government, despite its own impact assessments, wants to continue down that pathway. I just wanted to mention some particular race disparities for this conversation. Firstly, Black children are 4 times more likely to be arrested than white children. Since 2005, the percentage of Black children in custody has doubled. Currently, 57% of the youth justice system is made up of BAME children, compared with 18% of that cohort aged 10 to 17, which are ethnic minority. So well overrepresented, and a terrible situation for society and the country in terms of that inequality. In relation to arrests, In the year ending March 2020, Black children accounted for 17% of arrests, which is 7 percentage points higher than 10 years ago. The proportion of youth cautions have decreased for white children and increased for Black children over the past decade from 7 to 12%, while remaining broadly the same for Asian and other children. The proportion of Black children given a sentence or caution is almost 3 times higher than the proportion of Black children in the 10 to 17 population, who make up 4% of the overall general population in terms of a cohort. So again, greatly overrepresented. Finally, 15% of children in secure training centres and 8% of children in youth offending institutions identify themselves as Gypsy Roma traveller, when just 0.1% of the general population is recorded as Gypsy Irish traveller. So I'll leave it there because we've got a lot to discuss. That's just trying to give you some facts that we think are particularly important, which this bill will only make worse. Thank you.
Thank you very much for that, Jeremy. And also just wanted to thank you and all of our partners across the sector who've been working together on a coalition that's been focusing particularly on the issues that you've just described, both for children and adults, which there's a great deal of concern over. So I know that there's a separate briefing which picks up those issues which we have referenced in our own briefing. But thank you very much for the work that Equal's done in terms of that, in terms of highlighting the really concerning issues there as well. So thank you.
Thanks, Pippa.
Okay, we're going to move on now to the measures in the bill that we have concerns around treating children as children. So I'm going to hand over to Millie Harris, the Senior Policy Officer from the AYJ, to give an introduction before we move on to some of our member speakers. So over to you, Millie.
Hiya. Yeah, so I just wanted to talk a bit about the importance of treating children as children. So the UN Committee on the Rights of the Child is clear that children must be treated differently to adults in contact with the law, and contact with the criminal justice system should be minimised. I think it's well established now that contact with the criminal justice system is harmful and criminogenic and should be avoided wherever possible. The UN Convention on the Rights of the Child and domestic legislation is also clear that all those under the age of 18 are children. We're therefore really concerned to see multiple measures in the bill that treat older children as children, that fail to ensure all those who commit crimes under the age of 18 are treated as children, and that fail to have due regard to the distinct needs and the best interests of children and the need to safeguard children at risk of harm. This is true of the provisions around custody that we'll come on to discuss later, but 3 examples of this that we'll come to now are around the serious violence duty, turning 18 and virtual justice. So first we'll go to talk about the serious violence duty and child criminal exploitation, and we'll have Iryna, Pona from the Children's Society and Tyrone, Steele from Justice.
Thank you, Millie. I think I'll go first. My name is Iryna Pona and I'm Policy and Research Manager at the Children's Society. The Children's Society is a voluntary sector organization. We work directly with young people who are at risk or experiencing sexual or criminal exploitation and undertake research and policy work to help develop solutions. Through our work, gaps are persistently identified in responses to children who are criminally exploited. Firstly, there's a lack of shared understanding among local agencies such as police and social care, or between agencies in different geographical areas, of what child criminal exploitation is, how it is linked to serious youth violence, and what needs to be done to identify children early and to protect them. Good practice is developing, but it's not consistent across the country. Secondly, many children who are criminally exploited are receiving criminal justice response rather than being seen as victims of crime and protected. In 1920, close to 7,000 children were arrested for drug offences. Over 1,400 entered youth justice system for the first time on drug offences, and over 2,000 due to weapon offences. These offence groups have seen the largest percentage point increase compared to other offences with 10 years ago. These issues are also associated with criminal exploitation and serious youth violence. The National Referral Mechanism, a referral system for victims of modern slavery, recently introduced a separate category of criminal exploitation in recognition that this is a distinct type of exploitation, and there's been a huge increase in the number of children identified who are exploited criminally. In 2020, over 2,500 children, around half of all were referred to NRM because of criminal exploitation. Lack of shared and sometimes limited understanding of criminal exploitation of children, for example, seeing it only as county lines type exploitation, and the lack of focus on safeguarding of children mean that many criminal exploited children come to attention only when they are in trouble with the law and already trapped in exploitative situations. We believe that police crime sentencing and courts bill offers an opportunity to start changing this narrative. We are supporting amendments that seek to ensure that serious violence duty has a focus on safeguarding response to children and that child criminal exploitation is defined in the law. These changes would ensure that professionals across geographical boundaries have the same knowledge and approach in responding to children, and that the focus can shift from policing response to earlier safeguarding response, offering early identification and help for children who are groomed by criminal groups before they are trapped by their exploiters. The important national policy change can drive better and consistent local multi-agency practice, placing children's needs at the heart of response. And I hand over to Tyrone here.
Thank you very much, Iryna, for that important presentation, particularly in situating the serious violence duty in the lived experiences of children and highlighting the importance of safeguarding and those concerns in that context. I'm going to talk about now the serious violence duty, how it works in general, then some of the issues that we and some of the wider members of the Anti-Police Bill Alliance see in the duty, and then very briefly point to some amendments which a number of us, including some here on the call today, either support or indeed have actually tabled. So what is the serious violence duty? The bill sets out a serious violence duty as a duty for public bodies such as the NHS, schools, local government, etc., to collaborate with each other to prevent and reduce serious violence. So what does collaboration mean in this context? At a more benign level, the bill provisions for each of these kind of local authority or public bodies to make a plan to to organize themselves better to look at the issues of serious violence in their localities and come up with solutions. More nefariously is this obligation of information sharing, because many of us here wouldn't object to the government, public bodies taking more seriously the issue of serious violence, but it's just about how you go about it. So while the government has framed this duty in the language of a kind of public health approach, it's anything but. Instead, what it represents is a way of prioritizing kind of the police at the apex of this kind of information sharing network between public bodies, which thereby will allow them to set their priorities and place their priorities above other public bodies, in the sense that the police will be able to demand information from these other agencies, and they will have to comply, subject to some very, very weak safeguards that exist in the bill. So what are the issues with this new approach? I'd like to highlight four key ones, I think, or three key ones, in fact. So firstly, there's the issue of exacerbation of racial inequalities by placing the police in this privileged role. It allows them to monitor the exercise of the serious violence duty and place their priorities over those of the other public authorities. And we know that there's an issue of serious disproportionality in the criminal justice system as a whole, and the police are often at the forefront of this. And without addressing those underlying issues and concerns, you're only going to see those same issues translated across into the duty in the way that we already do with programs such as Prevent, or indeed the Gangs Violence Matrix. I think the second point to note is the discouragement from accessing services that a number of vulnerable communities and their children will face. If you have, say, a migrant, for example, who is worried about being criminalized when interacting with public services in general, the bill will make things much, much worse. For now, they have to fear that the police or the Home Office or other public bodies will request information relating to them from these bodies, which are supposed to operate in this kind of confidential space. So no longer will they be able to trust going to school or going to the doctor, that they're able to kind of authentically access these services. It places them at a disadvantage instead. And I think that brings on to the third point of this kind of information sharing and confidentiality issues. The bill allows the police to override confidentiality and, yeah, strong arm these organisations into sharing data and placing its priorities over there. And there are potential incompatibilities with Article 8 of the European Convention on Human Rights as well that are worth noting. In terms of amendments, I'll very briefly point to some which we'd support here at Justice and some of the wider Anti-Police Bill Alliance, and a briefing supporting those amendments will be coming out shortly. Many thanks to Liberty, Fair Trials, Stopwatch and a number of other organisations for kind of collaborating on that. The three amendments are as follows. The first is an amendment to remove the data sharing provisions, including carve-outs for crucial data protection safeguards. This is currently tabled in the names of Baroness Meacher and Lord Paddock, and it would remove the problematic requirements for data sharing and elegantly neuter the duty in that respect. The second is an amendment which would reinstate public bodies' statutory duties, again in the names of Baroness Meacher and Lord Paddock. And this would rebalance the obligations between the public bodies and ensure that there isn't kind of an over-prioritization of the serious violence duty vis-a-vis their own obligations, like the safeguarding ones that Iryna noted just before. The final amendment that I'd point to is the amendment to ensure that data that's shared through the serious violence duty is depersonalized, it's anonymized. And this will help prevent individualized risk profiling and allow individuals, particularly those vulnerable communities and their children, to feel greater confidence when accessing their services, but then also prevent the police from using the duty as a way to individually target individuals. And so on that, I'll leave it there and just express my thanks again to Pippa, Millie and the AYJ team.
Thank you very much to Iryna and to Tyrone for outlining some of that really important context around some of the issues around serious violence and child criminal exploitation, and then some really practical amendments that can be laid down in order to, I think the phrase was elegantly neuter, which is new to me, and also to kind of put some of those safeguards in place. So thank you very much to both of you for that. And as I say, there'll be an opportunity to ask all of the speakers questions at the end. So I'd like to move on to introducing our next speaker, who is Louise King, who's Director of the Children's Rights Alliance for England and Director of Policy and Campaigns at Just for Kids Law, to talk about the issues in the bill which are relevant to when children turn 18. So over to you, Louise.
Hi, thanks Pippa. So as Pippa said, I'm from Just for Kids Law. So as well as policy work, we also do direct advocacy work with children and young people to ensure their rights and entitlements are fulfilled, and also carry out direct legal representation for children in the criminal justice system, but also across a range of other issues like housing, kind of immigration and education and community care. And this direct practice and our experience of that really informs our policy work and the key issues that we see happening to children and young people kind of on the ground. Just for Kids Law also hosts the Children's Rights Alliance for England, which I'm sure some of you will already be familiar with, but for those that don't, CRAE monitors implementation of the UN Convention on the Rights of the Child and other human rights treaties to ensure that kind of the UK government is living up to its human rights obligations. So I'm just going to talk a bit about the issues we have in terms of what the bill doesn't address in relation to the inequities and unfairness for how children are treated where they have committed an offence when they are still children under 18, but actually turn 18 before the completion of their case. And although accurate figures aren't publicly available and actually are quite difficult to get, we did work with Youth Justice Board to try and kind of work out how often this situation is happening and how many children are affected. And it's estimated about 2,500 children annually are affected where they've actually, and these are proven offences, where they've actually tipped over into adulthood before their case has been completed. So this actually means a relatively large number of children don't actually currently benefit from some of the positive aspects of the youth justice system. Of course, as a children's rights organisation, we clearly know there's a lot of problems with the youth justice system, but nonetheless, there are still some positive benefits, and we think that all children any person who's committed an offence as a child should be able to benefit some of those positive aspects. And the UN Committee on the Rights of the Child, who monitors implementation of the UN CRC, has also been very clear on this issue. And a couple of years ago, they issued a general comment number 24 on children's rights in the justice system. And they stated very clearly that the child justice system should extend protections to children who are below the age of 18 at the time of the commission of the offence, but who've turned 18 during the trial or the sentencing process. And recently the UN Committee have actually asked the UK government what measures it's planning to take or have taken to try and address some of this inequity. And that's part of the examination which will be happening next year of the UK on how well they are respecting children's rights. I'm sure you won't be surprised to hear that there are delays within the criminal justice system, and this is really having a real detrimental effect on children and young people who turn 18, particularly because now quite a lot of first-time entrants to the youth justice system tend to be on the older age range, and that was obviously welcome that there's fewer younger children coming into the system. It obviously means there's a real urgency to actually look at this particular issue in terms of people having and passing a significant age threshold. So we've really seen, so since in December 2011, it took an average of 8 weeks for from offences to completion of cases in the criminal justice system in England and Wales. That's really grown significantly in recent years. So in the year ending December 2019, that had actually grown to nearly 6 months. So it's quite a significant wait. And obviously this has been really exacerbated by the pandemic. So more and more young people are likely to be impacted by this particular issue of turning 18 and having that particular important birthday. And we just think it's extremely unjust that a person has completely different outcomes and treatment just because they have turned 18 due to something out of their control, like delays in the system or the way their case hasn't been expedited. So you could end up with a scenario, we've had 2 children committing a very similar offence in similar circumstances, and yet the outcomes are quite different if one of them happens to have turned 18 but the other haven't. And it really remains unclear to us why the government isn't taking action on this particular issue. And we think there's many things that need to happen to address some of those inequities and unfairness that happen to these young people that turn 18. But there's some really straightforward things that we feel could be introduced in relation to this bill. 2 things we particularly want to see amendments are relation to rehabilitation periods. At the moment, they start from the age of the person when they're convicted. If this was changed to the age of the person when the actual offence is committed, it could have a significant difference. So, for example, at the moment, which is proposed in the bill, which is welcome in terms of shortening rehabilitation periods, if you receive a custodial sentence more than a year and up to 4, if you're under 18, you will have a rehabilitation period of 2 years. But if you turn 18, then it will be 4 years. So it's quite a significant difference and creates a clear barrier in terms of employment, for example, and actually enabling that young person to move on with their life. The other amendment that we'd like to see is to ensure that the sentencing framework is aspects of that is actually, and that guidance is placed in the bill to ensure that a person wouldn't receive a harsher sentence by the fact that they've turned 18 than they would have done if their case had been dealt with when they're under 18. So that's just 2 clear things that we think are fairly easy solutions which have a real big impact on this kind of growing group of children that are just treated unfairly because they've happened to have their 18th birthday.
Thanks very much, Louise. And it makes me think, I was in a meeting just this morning with a number of colleagues from youth offending teams who were talking about their concerns around the compounded impact of extended periods of children that are being released under investigation, added to the delays that are happening in courts at the moment, which can mean that that tipping point in terms of turning 18 can come around quite quickly because of the effect of both of those things brought together. So thank you very much. Okay, I'm going to pass over now to Penelope Gibbs, the Director of Transform Justice, to talk about video links and some of the concerns around the digitisation of youth justice, which is present in the bill. So over to you, Penelope.
Thanks very much. And we've worked on these this briefing and the subjects with Fair Trials and with Just for Kids Law. And Transform Justice has got a lot of research over time on this issue. So pre-COVID, the use of video links for child defendants was in exceptional circumstances. With the impact of COVID, obviously there was emergency COVID legislation, which brought in much looser guidance for the use of video links and audio links in the criminal courts, so that even trials, summary trials could be done, or video, and so on. So that was emergency legislation, which for understandable reasons was basically rushed through without the chance to scrutinize it, and really treated children in regard to video links and audio links very much the same as adults. So there was already considerable concern about the effect of video links, particularly in relation to child defendants and those with disabilities, even pre-COVID. And obviously we're very concerned that the bill simply takes the emergency COVID legislation and says that it should be enacted. And there's a bit of a chance for scrutiny now and to say, is this what we need and want in this new era where social distancing and so on is no longer as current? So what our concerns are principally about effective participation. And there is considerable evidence, both for adults and children, that effective participation is harmed if the defendant's on video, that they find it partly for the technology, partly just because video is a barrier. They find it much more difficult to understand what's happening in their hearing and to give their views when they want to say something. And what I would say is it's difficult enough for a child in the youth court in the first place to understand what's going on when they're there in person, sitting very near or hopefully next to their lawyer. If they're on their own in a room, or more or less on their own on a video, that is 10 times more difficult. And what we've had in the pandemic is child defendants appearing from police custody, the so-called video remand hearings, and we've had many, many more from prison. And what we're concerned about is that this bill just says, that's fine. There is no more kind of evaluation of the impact. So as well as effective participation, there's also research to say that those on video can get more punitive outcomes. So more likely to get prison sentences, perhaps more likely to be remanded. Obviously, that's very serious outcome for a child, or for anybody for that matter. And so what we feel is that we need to draw a line for video links for children, that there isn't a necessity. In most cases, still, they're not used, and children can be brought to court, and it is very important that they are. For administrative hearings where the child doesn't appear, no problem. But for ones where the defendant needs to appear and it's a substantive hearing, they shouldn't be on video. So we have 3 amendments we're calling for. One is a statutory presumption against the use of live links for children. We also would like if there's any future thought of using video and audio links, that there should be a full impact assessment, including those outcomes. Does it lead to more remand? Does it lead to higher and more punitive sentences? And then we are very concerned about disability, that if a child appears, say, from the police station where they could have slipped through the screening net, or from a prison for that matter, that it's much, much more difficult to pick up whether they have a disability, which will make it even more difficult for them to participate on video than previously. So those are the kind of changes that we're calling for, and it's mainly just to say we don't need it for children. It is very, very risky. I'll stop there.
Thank you very much, Penelope. And absolutely concur with the points around not bringing in measures permanently that have been brought in under a crisis, particularly for children, and particularly in terms of enabling them to participate fully in those really crucial decision-making points. So we've heard about some of the concerns around racial disparity that cut across the bill, and we've heard about some of the concerns around treating children as children. Next up, we're going to be thinking about custody and the provisions in the bill which we are concerned around the implications for custody as a last resort for children in the youth justice system. So first of all, I'm going to pass over to an introduction from Millie Harris and then over to some of our members. So over to you, Millie.
Just going back to the UN Convention on the Rights of the Child, so that sets out that the detention or imprisonment of children must be a last resort and for the shortest appropriate period of time. And the government itself, in the white paper that preceded this bill, set out its intention, for example, to ensure remand to custody was only ever used as a last resort. I think, so while there's been a welcome fall in custody numbers over the last decade, it does remain the case that custody is not used as a last resort for children or for the shortest possible period of time. We published a paper last year developed with our members that sets out that evidence showing where it's not used as a last resort. Also evidence on the ineffectiveness on custody, the harms it causes children, and the duties that local authorities and courts have to prevent that harm coming to children. So in that paper, we proposed a new higher custody threshold, some of which we're really glad to see has been adopted in the new threshold for custodial remand that our next speaker is going to touch on. But we would like to see our proposal for custodial sentencing added to the bill. It would be a really important tool in addressing the disproportionate number of racially minoritized children and children with care experience in custody. And it's particularly important given the crisis that's unfolding today around Oak Hill, for example, Oak Hill Secure Training Centre, and also recently in Rainsbrook Secure Training Centre. I think it's more important than ever to make sure that children aren't being sent to custody when they could be managed in the community. Unfortunately, despite the lack of evidence that harsher custodial sentences deter crime or contribute towards the rehabilitation of children, a number of provisions in the bill move us further away from ensuring custody as a last resort, or that it's for the shortest possible period of time. And we'll come on now to hear from Dr. Laura James, the Legal Director at the Howard League for Penal Reform, who's going to set that out.
Thank you very much, Millie. So yes, I've been asked to talk a little bit about the provisions in the bill in relation to the remand of children in custody and the custodial population. And I think Millie's set it out there very well that these two aspects of the bill illustrate the two opposing philosophies within the bill. One which is about reducing the use of unnecessary custody, and one which is about ratcheting up, in fact, the punitive nature of custodial sentences, and of course without, as Millie says, the evidence to support that in terms of it reducing the risk of crime in the future or being consistent with children's welfare. I'll be quite brief on the remand side of things, because as we've heard already, actually, it is generally positive. You can see on pages 18 and 19 of AYJ's excellent briefing for the second reading, some of the further tweaks that have been suggested, but it's really been broadly welcomed, I think, by most of us. But one thing that I think is very important for those who are thinking about how the proposals in the bill will unfold is that it needs to be accompanied by policy and practice change. There needs to be a cultural change to accompany those statutory provisions, because I think it is the case that we could have reduced the child custodial remand population under the current law if there had been the will and oomph, as it were, to do it, and that hasn't happened. And of course it's really important that it happens, because the shocking racial disparity that Jeremy talked about at the beginning of today's session is, you know, with over half of children in custody being from Black and ethnic minorities, is even more acute in the remand population. And we know that 9 out of 10 boys remanded from London are Black and ethnic minority. At the Howard League, we've been doing a project working with children on remand in a particular jail, and every single child we've worked with so far has been Black, and every single child we've worked with so far has been in the care system. So by addressing this issue, we really can get to address some of the most egregious harms of the situation of children in custody. I think that there are two things, though, that are missed opportunities when it comes to the remand provisions. I think the first one, and I think really the expert on this is Penelope from Transform Justice, is that actually the threshold for remand ought to be aligned with the police threshold when thinking about police bail or not, because the reality is that, you know, you often find children who end up being remanded at the police station who, when they appear in court, that, you know, the next available opportunity simply don't fit the criteria. And of course we all know that can be a hugely damaging and traumatizing experience. And when I talk to the children, I've been practicing as a solicitor now for 15 years with kids in custody, and quite often when I ask them, you know, what's your sort of, you know, what have you found most distressing and upsetting about the criminal justice system, it's almost always the time in the police station, particularly overnight in the cells. And the second thing is something that the Howard League has been really focused on over the last year and a bit, which is that it's been a huge missed opportunity in terms of removing the ability to remand children for their own protection or welfare. Now, this would simply be a strike through in a few clauses in the Bail Act. And I cannot imagine, particularly when we've just heard what Millie is talking about with the urgent notification issued today in respect of Oak Hill Secure Training Centre, but, you know, huge problems about the extent to which the custodial state is fit for purpose to protect and support children. The idea that we are still ostensibly sending children to prison for their own protection and welfare is just not one that can be accepted in the modern world, and it's a real missed opportunity. The Howard League has drafted simple amendments that would easily be able to rectify this, and that is something that ought to be done. Moving on to the custodial provisions in the bill. Then, so there are a number of provisions really that, as I say, will increase the length of time that children spend in custody. The first one is currently clause 101, which is about mandatory sentences for older children who are committing knife offences, and that just simply is going to further reduce judicial discretion to avoid custody for children with knife offences. And of course, the problem with mandatory sentences is it cuts completely against the grain of taking an individualized approach and acting in the best interests of a child. And we know from all the research that there's nothing about putting children in prison that's going to help reduce, stop or prevent knife crime. So it's not going to do the trick. We also know from all the HMIP reports, and of course my own experience of working for a long time with children in custody, that actually putting children in custody is exposing them to exactly the kinds of levels of violence that we want to take children who've been found with a knife away from, children who are often frightened and scared. So putting them in a hostile environment is really not a good idea. There's also clauses 102 to 3, which are about whole life orders for adults. I know we're focusing on children here, so I won't talk at length about that, but we've heard what Louise has said about turning 18. We know that over the last decade, there's been an evolution in knowledge about the fact that you don't grow up immediately on your 18th birthday, and your brain and your maturation continues to mature until you're 25 at the earliest, really. And so removing the right to hope, as it were, and also the option, making it clear to an 18 or 19-year-old that you will die in jail really does not sit comfortably with what we know about encouraging and fostering change. There's also clause 104, which is about the starting points for murder. Now, generally, we're becoming a nation where the proportion of people in prison serving life sentences is hugely increasing, and tariffs, minimum terms for people serving life sentences, have almost doubled in recent years. Now it's going from a 12-year starting point for any child who commits murder to a sort of sliding scale, which is based on chronological age, again flying in the face of what we know about development and an individualized approach. But it means that the most serious minimum terms will now have a starting point for 16 and 17-year-olds of 27 years, which is double the current starting point. Now, yes, they are just starting points, but they're inevitably going to have the effect of ratcheting up the sentence. And again, what we know is that very long periods of time in custody for children who will grow into young adults and even possibly older adults is not going to actually help anyone in terms of them rehabilitating better or quicker. There is also clause 105, which is about the minimum term reviews. Now, these are sort of one of the best kept secrets of the criminal justice system, in that they are quite rare, but they are one of the most positive aspects of the criminal justice system, because what they effectively do is they enable a child somebody who committed murder as a child at the halfway point of their minimum term to go to the High Court and ask for a progress review. And it's a very high test. They have to show to the High Court that they have made exceptional and unforeseen progress. But it does mean that everybody concentrates on what that child has been doing, how they're progressing, and whether or not they really have changed. And they may get a year, I think at most 2 years off, but it's an incredible motivator, and it's a good benchmarker, and it actually is probably one of the most incredible aspects of my job, representing children on these and young people on these kinds of cases, where you see incredible transformations, and you can see actually how the justice system can motivate change. And the provision in clause 105 simply strips that whole process away for anyone who happens to have turned 18 at the point of sentence. Now, who gets caught by that? Well, children who are being tried alongside adults, they'll be caught by that, not their fault, presumably. Also, children who are particularly vulnerable or complex and might have their sentencing delayed because they're having reports on whether or not, for example, they have autism or something. So it's a very arbitrary cutoff point, and it's a change that does not make sense. Finally, clauses 107 to 8 deal with the late release provisions. So this is whereby currently people are released at the halfway stage. It sort of increases it to the 2/3 stage in certain determinate sentences. Now, the impact of that again will mean that you'll have a number of children who are on serious sentences who will then go into the adult estate before they are able to be released on license. That transformation in itself is a very difficult one, and can also cause a lot of difficulties. It may also mean they're losing time if they are a care leaver in the community with social services to support, to rehabilitate them. And it also means they'll have more time in jail, but less time under the supervision of probation or the youth offending team, which actually is not good for them, and it's not good for victims. So that's a kind of run through of the kind of key concerns arising in the custodial provisions, and I'll leave it there.
Thank you, Laura. Thank you for spelling out so clearly what those concerns are, how they link to Jeremy's points around the culmination of that disparity throughout the system, and also really bringing to life from your work as a practitioner kind of what some of the implications and some of the unintended consequences potentially will be. So very much appreciate that. Thank you. We're going to move on now to hearing from Carolyne Willow, the Director of Article 39. We're now going to be moving on to the secure schools provisions in the bill. So we've covered remand and sentencing, but the bill also contains provisions around the government's plans for the rollout of secure schools. So I'd like to pass over to Carolyne to walk us through some of that. Thank you, Carolyne.
Thanks very much, Pippa. So I'm going to describe two modest proposals, proposals for two amendments with a very bold but honest claim. The proposed amendments, which have been put in the Commons, are one, to allow local authorities to be able to run secure 16 to 19 academies, also known as secure schools. And secondly, to put on the face of the bill a ban on profit. The bold but honest claim is that if peers were to propose and manage to incorporate these two amendments into the bill, it will stop another generation of children suffering terribly. And we know this because we are just at the tail end of the Secure Training Centre experiment, which started in terms of children's experiences in 1998, but of course the proposals preceded that in the at the start of the 1990s. So to take us back to Lord Ramsbottom in 1997, when he was Chief Inspector of Prisons, he led a thematic review of young prisoners. And he said then, prison is no place for children. The institution, the prison service, the buildings, the culture were never ever designed with the needs and rights of children and the welfare of children in mind, and that they cannot be reformed. That was in 1997. Fast forward to December 2016, and the government of the day, the Ministry of Justice and the Youth Justice Board together conceded that our prisons for children, the young offender institutions and the secure training centres cannot be reformed. They're not fit for the purpose of protecting and keeping children safe. And so in December 2016, the government pledged to phase out child prisons, to phase out young offender institutions and secure training centres, and to replace them with secure schools, which in this bill are referred to as secure 16 to 19 academies. Now, what's changed with the secure schools, secure 16 to 19 academies from the child prison model is that legally these establishments will have to follow childcare standards. They will be registered as children's homes. They will have to follow, which is in law, the children's homes quality standards. So far, so straightforward. If that was the only part of their legal makeup, then local authorities would immediately be able to manage and run them. But they are a hybrid. They've been made into a legal hybrid of the children's homes and academies. And when the government put out the tender for its first experimental secure school, it would not allow local authorities to bid to run that secure school. Now, secure children's homes, the only bodies that have any experience of looking after, protecting, educating, taking care of children who are remanded and sentenced to secure children's homes, the only place of expertise in our country is local authorities. That's where that expertise lies. So this is why I say it's a bold but honest claim that if local authorities are not allowed to be part of this new type of establishment, then we are all part of yet again a new experiment in a locked environment which is sure to fail children. We have at Article 39 and other organisations at our fingertips the evidence, and I've only got 3 minutes and I've probably used that already. That can be provided to peers in a very succinct form. We've got the Secure Training Centres experiment from 1998 to today. We had 4 secure training centres run by Serco and G4S. The last remaining one today has been subject to an urgent notification process, which is the highest level of safety notice available to the inspectorates, and the young offender institutions similarly are not fit for purpose, and the government has conceded this. So our 2 amendments, one would allow local authorities to run these new establishments, and secondly would put on the face of the bill an outright ban on any organisation in the future making profit out of running establishments where children are deprived of their liberty. G4S, Serco, MTC Novo, we've had that experiment of organisations running locked environments for profit, and I can absolutely say that it impedes and compromises child safeguarding.